What I'm about to share is a scandal worse than Watergate. Spying on the confidential cell phone communications of a United States senator. That's what we heard from FBI Director Kash Patel, disclosing a confidential FBI document hidden inside of the FBI's database that amounted to spying on at least 9 senators, and it's still counting. During this episode, I'm going to break down exactly what happened. I'm going to show you the case law around it. And of course, as you know, I'm going to give you a significant legal explanation as to why this is so problematic coming from the FBI. First, an FBI document dated September 27th, 2023, said that there was a preliminary toll analysis for 9 lawmakers around the January 6th time window. It's stamped cast assistance. Now, cast is something we're going to talk about in a bit. The document flags the matter as election law and classifies it as a sensitive investigative matter. The list of names includes Senator Lindsey Graham, Bill Hagerty, Josh Hawley, Dan Sullivan, Tommy Tuberville, Ron Johnson, Cynthia Loomis, of course, Marsha Blackburn, and Representative Mike Kelly. This is not a rumor. This is a confidential FBI document that was hidden inside FBI databases that Kash Patel surfaced himself. According to the Associated Press, investigators looked at basic call record information, dates, times, numbers. They weren't able to get the content of the call, but still there was a significant intrusion. It claims that this step was authorized by a grand jury, but not a grand jury against these lawmakers. The AP also notes the time window covered several days during a week of January 6th, 2021. And crucially for people watching the timeline, the memo post-dates the August 2023 indictment of former President Trump, now President Trump. Why is that significant? What information did they need? They'd already indicted Trump. Senator Grassley's office adds 2 details to the matter to anyone who cares about oversight. First, the records span January 4th through January 7th, 2021. The second data set does not include the content of the call, but it does show duration and general location information about the phone calls that the lawmakers made. And the memo, Grassley said, was found inside a restricted, prohibited access file. That's a bucket that the FBI has designated to limit who can even discover if a record exists. That's why it was so hard to find in the first place. Why is this a big deal? In 2023, the government doesn't treat toll analysis, cell phone records, like your grandfather's long distance bill. The FBI's Cellular Analysis Survey Team, CAST, exists to turn call detail records and associated tower information into maps and timelines. They were trying to make maps and timelines by analyzing cellular call detail record associated with some of the most powerful lawmakers in Washington, all being Republicans. Metadata includes their movement, tracked down to a couple 100 meters. Now, equal justice means the government follows the rules even when it thinks the stakes are high, especially when the targets of an investigation are members of a coordinated branch of government. That's not partisan conviction, that's a constitutional one. So let's set the table on this. We've got a document, we've got a date, we've got 9 elected officials, we've got an election law label, we've got this document being hidden inside the FBI database, and we have it tagged as a sensitive investigation matter, effectively classifying it. Now, the Associated Press said a grand jury authorized this tap. What does that mean? That means that lawmakers would have had to go to grand jury members during the investigation of someone, we don't know exactly who, and say that there was probable cause to believe that these cell phone records would show evidence of a crime. Tell me what crime 9 Republican lawmakers could have potentially committed. Is it that they were trying to overthrow the government? They were engaging in insurrection? Sounds a lot like using unlawful wiretaps and unlawful searches of information to spy on your political operatives. And in fact, that's exactly what the Supreme Court has said, that this would be consistent with a Fourth Amendment violation. In 2018, the Supreme Court in Carpenter versus United States held that accessing historical cell data location generally requires a warrant because those records provide a comprehensive chronicle of the user's past movements. This isn't like a house. Somebody's entire life can be inside of their phone. That's the Supreme Court's rationale. Cell phones contain a whole bunch of data. So the debate is not, can the FBI ever look into toll records? Of course it can, with the right process. The question is, and nobody's above the law, we learned that phrase, right? The question is whether this preliminary toll analysis run by location mapping team for sitting senators included tower sector fields or other historical CSLI that normally triggers the Supreme Court's warrant rule in Carpenter. If it did, a grand jury subpoena or a lower threshold court order would not be constitutional for this type of intrusion. If it didn't, and it was truly just the numbers and the dates, then the ordinary tools may be enough, such as a search warrant. But again, they didn't have evidence on these specific lawmakers. So the question for us all to ask is, was this constitutional? The Stored Communications Act, Title 18, Section 2703, says the government can compel non-content records in a few ways. These are non-content because they don't contain the language of the text. One is a warrant, the other is a court order under 2703, which demands specific articulable facts showing reasonable grounds that the records are relevant to a material and ongoing criminal investigation, ongoing. A third route is the grand jury or administrative subpoena for enumerated categories like subscriber information and connection records. Notice the sliding scale. The more sensitive the information, the more heightened the process. At the same time, the Stored Communications Act is its own guardrail. You can't just log into a provider's system, Verizon's system, without authorization. The Stored Communications Act criminalizes, makes it a crime to engage in unauthorized access to a facility providing electronic communication, meaning what the FBI did here could potentially be criminal. There's lawful purposes and then there's unlawful purposes. But here's the underappreciated wrinkle related to this conduct. The Stored Communications Act remedies are mostly statutory. It says that those statutory remedies are the exclusive judicial remedies for non-constitutional violations. What does that mean in sort of lay terminology? It means that unless they violated the Fourth Amendment, the Stored Communications Act tells you what the punishment is, and that's a misdemeanor or potentially a felony if there were aggravating factors. And I'll explain in a bit why there are aggravating factors, making this conduct potentially a felony conspiracy. Now, the memo that we talked about earlier, and I showed earlier, labels this an election law sensitive investigation matter. The FBI's Domestic Investigations and Operations Guide puts elected officials, political organizations, and press squarely in the sensitive category with elevated approvals and documentation. Sensitive investigations are supposed to get more eyes, not fewer. Did this investigation get more eyes from higher level approval? Well, Kash Patel says he can't even really figure out who approved these warrants. If you're in federal defense work, you learn fast that metadata can be more intrusive than content. A phone bill doesn't repeat what you said. It can reveal where you likely were, who you orbit, how your day starts and ends, who you communicated with. If you're an elected official, that metadata might map legislative strategy meetings, committee calls, even the travel pattern to a secure facility. It's not the words, it's the web of information that is really important here. Now, let's talk about this toll analysis and these toll records and what sort of information they contain. Well, this call record would say who you called, how long you spoke to them for, and it would say the other people that the people around you called as well if their records were obtained, and you can create a web. Now, this analysis shows two-hop relationships, which means that you can look at the phone records of one person and then look at the phone records of who they called and put together a web of a lot of people and a lot of information. Now, the AP reporting on this says that this was authorized by a grand jury, and that's perfectly normal for basic toll records under 2703, the Stored Communications Act. And the FBI's own memo ties this work to the CAST team, location specialists. They're trying to find the location of these individuals. If that general location came from a historic cell site data, then that Supreme Court case I talked about, Carpenter, says you need a warrant. And the grand jury process would not be enough, making this a constitutional violation. Now, let me take a break here. If you're finding this breakdown useful, Make sure you tap like and subscribe so that more people will be able to see it and understand what the law is behind these issues. Now, I told you earlier that this was a sensitive investigation matter. That's how the FBI labeled it, and there had to be approvals. Who likely would have approved this? Well, if you're going to basically tap the phones of high-level individuals, you need eyes on this to make sure that it gets approved. And that would be the Deputy Attorney General at a minimum, or maybe even the Attorney General of the United States. But if we're talking about 9 lawmakers and political opponents, I would imagine that you would want to get presidential approval on that. This gets a bit more complicated given the fact that presidential approval was not an easy thing to come by, given Joe Biden's state in 2023. If you want to learn about that, you might want to watch the AutoPen video that I did earlier to see some of the issues with using an AutoPen for these sorts of approvals. It's clear that during the Biden administration, especially during these times, you had people running amok. You had people engaging in conduct without proper authority because there wasn't really anyone running the show. So we've got prohibited access to these sorts of records. We have potential constitutional violations, which we need to see accountability for. What types of crimes could we see these people charged with? Well, first, some are already charged with a conspiracy to violate civil rights. We've got Jim Comey already charged with a 1000 violation and 1001 violation and lying to Congress. We're probably going to see charges against some of these people for obstruction of evidence because remember, I told you that these records were hidden and unable to be found and were not properly accessed in the right location. You can only imagine the shredding party that must have ensued when they realized that Donald Trump was going to be the next president of the United States. Section 242, 18 U.S.C. 242, criminalizes deprivation under color of law. That's basically when people like this go outside of the law and use their lawful authority to do something wrong. Proving willfulness is the hard part of a case like that, but of course, if you don't have any evidence that these lawmakers' records should have been disclosed, that's going to be not a difficult fight. And let's be equally clear about what this memo does not show. It doesn't say why the lawmakers were chosen. It doesn't say the evidence against them. It doesn't indicate whether there were any meaningful tips. There's no public evidence of any wrongdoing by any of these lawmakers, and it doesn't appear that any evidence surfaced afterwards, and certainly none of them have been charged. What does that mean? Well, it means that they were spied on when there was no evidence that we can find necessitating one of the most drastic intrusions since the break-in at Watergate. Operation Arctic Frost, that's what they called it. Arctic Frost appears to be about the spying on your political opponents. It appears to be about charging your political opponents with crimes. The irony about Operation Arctic Frost is that just about everybody who took actions in furtherance of this kind of thing, if this was Arctic Frost and what it was really about, is going to potentially face criminal charges themselves, including Jack Smith, if he authorized this and knew about it. Case agents or cast analysts who scoped and ran the analysis would have had supervisory approval, but the people who approved it were the ones required to make sure they were doing the job they were supposed to do. This could go all the way up to the Attorney General, Merrick Garland. It could rest with the Deputy Attorney General. Of course, if you're going to spy on lawmakers like this, I would imagine that you probably would want to go all the way to the president. But of course, this is a problem endemic with us hiring Jack Smith, an unelected official, to go traipsing through the government, attacking anybody he wanted to, using any means that he wanted to get information on people, and then in some cases releasing that information selectively in order to attack. For sensitive, compartmentalized information like this, giving access might make sense, but we would want the right people to get there. So what exactly did CAST analyze? Well, the CAST policy guide, if you look at it, confirms the bread and butter is to look at the call detail records plus the tower and sector associations assigned where these people were. If the tower and sector fields were present here, the safe harbor is a warrant. You can go get a search warrant and you're covered. So we have a potential constitutional violation, a potential criminal violation, and a potential cast of characters that look quite powerful. What should we do next in order to get after this? What is Congress going to do? Well, first, they're going to find out who was involved in this, and they're going to look at all of the information around the investigation to find out what the approval level was and hold those people responsible. They're also going to look to see what information was gained and what information was gained using the information that they got from this unlawful search. That's something called fruit of the poisonous tree in the law, where if you try to build a case based off tainted evidence, everything that happens after that is somewhat tainted. Now, I mentioned that this could go all the way up to Jack Smith. It could go up to Merrick Garland. It could go up to Joe Biden himself. But of course, he'd get the benefit of the immunity he fought against Trump for. Let's see how it goes up to each and every one of those levels. In order to get something like this approved, it has to be signed off. In order for it to be signed off, there needs to be a memo that is sent indicating that there's information that can be gained, probable cause. One of two things happened. Either somebody lied in a memo to try to say that there was evidence that these lawmakers were engaged in criminal activity, or the person in the supervisory position didn't properly do their job. I'm guessing it was probably a little bit of both. Remember, we've got James Comey lying about the Russiagate dossier, and it seems like it was kind of culture within those circles of the FBI to not be completely honest on the applications that they put forward. But we also see very lax standards in the approval level, especially when Jack Smith got to create the team that he wanted to create to investigate this. And he certainly was very politically motivated during his investigation, and I imagine his teammates would be too. Now, we see some people throwing around statements like espionage and treason. Could it rise to that level, a capital offense? I don't know that I would go so far as to espionage unless this information then ended up in the hands of a foreign enemy. That's typically what we would see. But if that happened, and in fact any of this stuff was fueled by a desire to benefit a foreign actor, then I certainly could see something like that. We'll have to look and see if there's more. Now, the senators named in this memo have been outraged publicly at the fact that this happened, and they're entitled to ask hard questions. And I'm sure we're going to see congressional investigations getting at the heart of the matter, and we're going to see Kash Patel getting at the heart of the matter. But most likely what we will see is a lot of difficulty getting answers about who was involved, because those people who created this are very secretive about what they do. They hid this information in a place that was hard to find. In fact, the only reason they found it, the only reason Kash Patel found it, is because somebody bragged about it when they were applying for a position within the FBI. No one's above the law, and trust is a very important thing when it comes to government. The most damaging thing about this is the hard-working men and women of the FBI have their reputation tarnished because of a few yahoos who decided to go rogue and attack political opponents. That's why justice exists in this country. Those people who hold positions of authority like FBI agents, special counsel, deputy attorneys general, and of course the Attorney General of the United States raise their right hand to support and defend the Constitution. Which one? The one that we all follow, the one that we're all required to follow. And when you fail to uphold the Constitution, you fail to support and defend the Constitution, but instead you attack the Constitution and you violate its amendments, then you have to face justice. The federal government has done a good job of immunizing itself from these sorts of things. The average citizen wouldn't be able to sue for something like this. But we do have the ability to unseat people who do this and clean up the FBI. What we need to be very careful of here is that we specifically find those involved, that we look for specific evidence and information. We don't make the mistakes that these people made by jumping to conclusions and assuming political affiliations carry the day. But we also look to those people who are willing to come forward with information, whistleblowers, and see what they're willing to say about these sorts of activities. Now, my hope is that we have several whistleblowers who come forward and start talking about these internal conversations. I imagine the emails have been deleted. I imagine that documents have been shredded, and this is going to be a difficult investigation. But I think eventually we're going to get to the bottom of it, because some brave men and women decide that the Constitution is more important than their reputation or the reputation of the wrongdoers. Now, I imagine we've got a lot of people watching this show who may have been or were in the FBI at the time this all happened. And I imagine we've got some friends and family members who might see this show. And my message to y'all out there is, if you know something about these sorts of activities, if you know somebody's involved, You can only damage this country and the Constitution by keeping it to yourself. We need brave men and women to come forward. We needed them to do the right thing back then, but we need them to do the right thing right now in order to avoid things like this from perpetuating into simple political warfare. There are great Democrats, there are great Republicans, there are great people inside of the FBI. And then there are people who flagrantly trample the Constitution of the United States and the American flag. Those people should be an enemy to everyone. The time for political gamesmanship is over, and the time for cleansing within the FBI needs to begin in order to preserve the reputation. It's very sad that our rules were used to spy on these individuals. But it's even more sad that our rights were trampled by those people conducting the January 6th investigation. It was a violation that wasn't limited to lawmakers, but in the next episode of Off Air, I'm going to talk about how the rights of anybody in Washington, D.C. around January 6th were flagrantly trampled on by Jack Smith and his counterparts through the same use of unlawful violations of the Fourth Amendment, but this time in concert with some of the biggest banks in the United States. As you know, in this show, we speak truth to power. If you like seeing something like this, click like, subscribe, comment, let me know what you want to hear next. But in the next episode of Off Air, I'm going to talk about how during January 6th, the FBI and lawmakers were able to obtain warrantless searches into the bank accounts of nearly every American who was in the Washington, D.C. area around that time, over 30 million Americans. The Fourth Amendment right now is dead. We need to breathe some life into it. And the way that we do that is by shows like this and by the commentary that you provide. I hope you enjoyed this episode, and I hope you stick around for the next episode. I'm Ron Chapman, and this is Off Air.